This week, the Supreme Court made a huge decision where it ruled that federal courts don't have the authority to issue nationwide injunctions. The High Court's ruling reshapes how federal policies, also referred to as rules or regulations, are challenged in court. Before the ruling, a single judge could halt a federal policy nationwide, even if only one person sued. It effectively gave the judge the power to halt nationally debated policies with the stroke of a pen, often without full evidentiary hearings or thorough appellate review. Critics have long argued that this gave individual judges too much power and distorted the federal court system, which was designed to allow legal questions to be sorted out through different jurisdictions. The decision marks a sharp reversal from recent years in which lower federal district courts have basically tied the hands of President Trump from carrying out the policies that he was elected on. In fact, of the 40 nationwide injunctions filed against President Trump's executive actions in his second term, 35 of them came from just 5 jurisdictions including California, Maryland, Massachusetts, Washington, and the District of Columbia. These politically aligned jurisdictions have increasingly used nationwide injunctions to stall or halt federal policy. Writing for the majority, Justice Amy Coney Barrett declared that federal courts don't have the authority to issue sweeping nationwide injunctions. Justice Sonia Sotomayor issued a dissent, which was joined by Justices Elena Kagan and Ketanji Brown Jackson, arguing that the court's holding allows the government to continue to enforce an unconstitutional order against parties unless they file their own suit. Separately, Justice Jackson argued that the holding is an existential threat to the rule of law, and that courts must have the power to order everyone, including the executive, to follow the law. Jackson claimed that the majority focused on inapt comparisons to impotent English tribunals. Barrett rebuked Jackson by saying, "We will not dwell on Justice Jackson's argument, which is at odds with more than 2 centuries' worth of precedent, not to mention the Constitution itself. We observe only this. Justice Jackson decries an imperial executive while embracing an imperial judiciary." She went on to say that no one disputes that the executive has a duty to follow the law, but the judiciary does not have unbridled authority to enforce this obligation. In fact, sometimes the law prohibits the judiciary from doing so. Barrett continued critiquing Jackson's reasoning and cited the Judiciary Act of 1789, which requires judges to observe their limits on judicial authority. Barrett said Jackson skips over that part because the law involves boring legalese, and Justice Jackson would do well to heed her own admonition. Barrett went on to say, "Everyone, from the president on down, is bound by law. That goes for judges, too." The Supreme Court did not ban injunctions altogether. Lower courts still retain the authority to issue injunctions as to the parties before them. They may also entertain class actions, which, if certified, can extend injunctive relief to the entire class. But the bar for class certification is high, and certainly more demanding than the expedited injunctions that have become common in high-profile political cases. The decision also does not keep states from seeking relief limited to their own jurisdictions. However, the days of one judge in California or Washington issuing a policy-blocking order affecting the entire country appear to be over. The court just tightened the leash on judicial power. For better or worse, policies won't be frozen nationwide anymore by a single lower court. In sum, the court has recalibrated the balance between the judiciary and the executive. More pointedly, the ruling resets the legal battleground heading into the next phase of federal policymaking. The Trump administration is already signaling its intent to move forward with its policies like ending birthright citizenship, ceasing sanctuary city funding, suspending refugee resettlement, freezing unnecessary funding, stopping taxpayers from funding transgender surgeries, and much more. Yet the decision carries broader consequences. Nationwide injunctions were also used by Republican-led states to halt controversial Biden-era policies, including vaccine mandates and student loan forgiveness. That legal tool is now off the table for them as well. This is not a moment of triumph for one political party, but a reassertion of judicial restraint. Whether that leads to greater constitutional clarity or merely shifts the legal fights to new terrain remains to be seen.